Hello, everyone. Welcome to Uncivil Law. So, as I'm sure many of you know, the Sarah Boone trial was supposed to start today with jury selection, but then a hurricane happened, a literal act of God. And so jury selection has been delayed a week. So Sarah Boone gets her continuance, I guess. Apparently, she was offered a plea deal at 15 years on manslaughter, and she turned that down, which sounds like a bad deal to me. Because, she'd presumably be out in like something less than that, 10 years or less. And she's facing 22 plus on the current charge, so, which she will be convicted and probably get double what she would have gotten otherwise. So it seems like a bad deal. So I don't know, but that's apparently what she's going with. So jury selection is supposed to happen next week. Maybe she'll reconsider, assuming that the state lets her. But apparently jury selection's been delayed a week, and we will do next year. So we'll see. Yeah. Yeah. Whether or not she can change her deal is up to the state, right? Because it's like any offer, right? The offer only exists as long as both parties want it to exist. So the state can withdraw the offer at any time. And, until it's accepted, obviously. It's like any offer. Until there's an acceptance, there's no agreement. And there's no contract. So offers can be withdrawn, until they're accepted. So yeah. Yeah, she's already served 4, so why not take the plea? That's actually a really good deal, a really good point. I haven't even thought about that. She's already served 4 years, so she'd be out in like 6. That's a pretty good deal, man. Yeah, so that's a good point. I didn't even really consider the fact that, yeah, obviously credit for time served. So that's what's happening. Also, on a different news, the U.S. Supreme Court has started its session today. I know, I'm excited. It's Supreme Court Day. Yay! Supreme Court Day, it's a glorious day for you and me. For you and me, it's a glorious day. Let's take a look and see what's going on in Supreme Court land. There was one on an exhaustion issue on 1983. Whether or not you had to exhaust state remedies before filing a 1983 claim, which I'm not sure why you'd have to. I would think the answer is no, but the Supreme Court apparently took up the question, so apparently there's more to it than I initially thought. Oh my God. Good Logic versus Merchant is on the emergency docket. It's been officially filed. That's funny. That's funny. Should we take a look at Good Logic's officially filed application? Yeah, he filed. It's on the emergency docket. Good Logic filed. Oh, Lord. Have I seen interviews with neighbors and friends? No, I'm not really. Let's see what's happening. What is today? Oh, I want the current term, 2024 term. Let's see. Whether exhaustion of state administrative remedies is required to bring a claim under 1983 in state court. From the Supreme Court of Alabama. Interesting. What is going on in this case? Let's take a look. Let's take a look at the petition, and then maybe take a look at the underlying decision. That'll be interesting. Here I am, rock you like a hurricane. Here I am. All right, let's take a look at what's going on in this Supreme Court case. Williams versus Washington from Alabama. Whether exhaustion of state administrative remedies is required to bring a claim under 1983 in state court. That's interesting. So you brought a 1983 claim in state court. That's interesting. Why did you do that? I'm sure there was good reasons. In Patsy versus Board of Regents, this court held that exhaustion of state remedies should not be required as a prerequisite to bringing an action pursuant to 1983. In this case, a sharply divided Supreme Court of Alabama required petitioners to exhaust their state remedies prior to bringing suit, which is precisely what the court prohibited in Patsy. The Supreme Court of Alabama reasoned that Patsy does not apply in state court. Okay, but that conclusion cannot be squared with Patsy's reasoning and contradicts numerous cases from this court, establishing that state courts must heed this court's interpretation in 1983. As the dissent below recognized, the Supreme Court of Alabama decision conflicts with decisions of several state Supreme Courts and defies this court's precedent. Petitioners are Alabama residents who filed unemployment compensation claims with Alabama's Department of Labor. After experiencing extreme delays in the proceedings of their applications, petitioner filed suit under 1983, alleging that the respondents' failure to act on their applications and provide the notices and hearings to which they're entitled violated their rights. Though all the Supreme Court of Alabama recognized that all petitioners' claims were federal claims brought under the Civil Rights Act, it nonetheless dismissed petitioners' amended complaint on the ground the state courts lacked jurisdiction over the 1983 suit. The sole basis for the court's dismissal was petitioner's failure to exhaust administrative appeals process governing employment compensation claims provided for by state law. Okay. In reaching that conclusion, the Supreme Court of Alabama explicitly acknowledged the court's decision in Patsy, but said that the 1983 plans could not compel state courts to adjudicate federal claims that lie outside the state's court jurisdiction. I like it. I like it as an idea. That's a really interesting idea on what is it on when you force someone to do something else that you want when you want them to do, when you try to commandeering doctrine. It's an interesting idea on commandeering doctrine. It's like, this is a federal cause of action. The state courts can adjudicate the federal cause of action, but you can't make them. That's interesting. That's an interesting idea on anti-commandeering doctrine. I think I like it. The reasoning defies Patsy. Patsy held that exhaustion of administrative remedies in 1983 actions should not be judicially imposed. The interpretation of 1983 applies in all courts, state or federal. State courts may not ignore this court's interpretation of federal statute. That's a fair point. So then I suppose the operative question could be, can the state refuse to adjudicate it at all and leave it solely for the federal courts? So if you're going to adjudicate it, you have to do it this way. Makes sense. But can you be forced to adjudicate it is an interesting idea. Okay. Felder versus Casey confirms what's clear on Patsy's face. Patsy's no exhaustion rule applies equally to 1983 claims filed in state court. As the court explained, there's simply no reason to suppose that Congress meant to provide individuals immediate access to federal courts, notwithstanding any provision of state law to the contrary, yet contemplated that those who sought to vindicate their federal rights in state court could be required to seek redress in the first instance from the very state officials whose hostility to their rights precipitated their injury. which makes you wonder why you're bringing in state court in the first place, to be a little bit honest, but okay. Whether in federal court or state court, administrative exhaustion remedies impermissibly interfere with 1983's central purpose of providing compensatory relief to those deprived of their federal rights by state actors. Interesting. In addition, this case meets other criteria for certiorari. As dissent below observed, the Supreme Court of Alabama's decision conflicts with the decision of several other state high courts that have read Patsy to compel state courts to hear 1983 claims that have not been administratively exhausted. This is a good vehicle to resolve the question presented because a failure to exhaust formed the only basis for the Supreme Court's decision below. And the question presented is of great legal and practical significance, both for clarifying the proper role of federal and state courts in enforcing federal civil rights law and ensuring that civil rights plans while certainty as procedural rules. I like it. That's pretty interesting. Thank you, Jennifer, for the $2. It is extensively appreciated. Thank you very much for your super chat. All right, let's read the Supreme Court of Alabama's decision because I think I like it. All right, from the Supreme Court of Alabama, Justice Mitchell is writing. With the onset of COVID-19, the Alabama Department of Labor received a record number of applications for unemployment benefits. To be precise, Alabamians filed nearly 1.5 million such applications with the department between April 2020 and March 2022, far above the 737 applications that had been filed in May 2019 before the onset of COVID. Yeah, that's rough. That's rough, So in May 2019, we had under 1,000 applications, and in a 2-year span, we had 1.5 million applications. That's pretty rough. Pretty rough. The plaintiff appellants in this case, who we refer simply as plaintiffs, are among the many individuals who experienced delays in the handling of their implications. Early last year, they brought lawsuit in Montgomery Circuit Court in an effort to jumpstart the administrative approval process. In their operative joint complaint, each plaintiff has raised multiple claims of relief, all of which seek to compel the Alabama Secretary of Labor to improve their speed and manner in which the department processes their applications. Yeah, we better have a trial. I need things to cover. I tell you what, I'm all personally in favor of Sarah Boone. Hey, Donna Haleman gets $2 to say I'm an Alabamian. Hey, we love people from Alabama. Thank you for joining our nice little foray here. We love having you. Yeah, I'm all in favor of Sarah Boone going to trial because I was kind of like looking forward to it in live streaming it. I was kind of looking forward to it, and be a little bit honest, I'm a little bit bummed right now because I basically had my next several weeks of content planned because I was just going to do trial coverage. I was kind of looking forward to not doing edited stories for a while and just doing trial coverage. It's nice to be able to go back and forth. It's nice being able to have those choices. And now I don't have a trial to cover, and now I'm sad. It's very disappointing for me on a personal level. So I'm all in favor for going to trial because I need the coverage, man. I need my trial fix. I need my trial fix. Inject it directly into my veins, man. Inject it directly into my veins. This suit began when 26 plaintiffs filed a complaint and motion for injunction release against Secretary Washington and the department, with each plaintiff pleading numerous claims related to the department's handling of their unemployment benefits. In essence, each of the plaintiffs had filed one or more applications for benefits and was unsatisfied with how they handled or failed to handle the application. Did you miss a ruling from the judge? It just was put on the docket. So there wasn't like a ruling in court. It was just put on the docket. So, yeah. This whole trial could be popcorn material. There was a nice motion in limine filed by the state, and I think they're right, incidentally. There was a motion in limine that said, basically in so many words, that Sarah Boone can't provide any evidence relating to battered spouse unless she first provides evidence relating to self-defense. And I'm like, that makes sense. And because it's a burden of production kind of thing. It's like you have to make the minimum threshold, which basically forces her to take the stand, which she was going to do anyway, because there's no other way to get in that evidence, right? It is necessary for her to take the stand to offer this defense, but it would essentially force her to take the stand first in the trial, because she wouldn't be able to, offer it except by her getting on the stand first to make the initial threshold showing under the burden of production. 499 said, spend the week updating YSL. No. I appreciate your enthusiasm and all, but there is no way on this earth I am dipping my toe into the YSL waters. I cannot possibly dip my toe into that pool of insanity and come out the other side. It's too much, man. It's too much. I cannot try to unwind the YSL trial back to life beginning so that I can understand it and try to explain whatever bullshit is currently happening. Okay, it's a lost cause, people. It's a lost cause. Abandon all hope, all ye who enter here. Okay, you cannot do the YSL trial. It is a complete nightmare fuel. There is no way on the face of this earth that if there's a conviction, it isn't reversed. Okay, so I'll just pick up the YSL trial the next time around. Whenever that is, like 3 years from now, I'll pick it up the next time there's a YSL trial. Holy shit. So it is far too late for Uncivil to try to dip his toes into this and make sense of it. Although I did hear that Maya filed a brief, or the hospital did, or somebody. What's YSL? It's a criminal trial in Georgia. It involves some rappers, and it's a RICO nightmare. It is a complex, it is the most convoluted case of our time. Don't worry about it. Anyway, so maybe I should do the Maya thing today. That'd be good. So do I have a brief on that? If not, I need to get one. Part trial, part circus. Yeah, pretty much. That's, yeah. Rico no go. Yeah, no, it's an absolutely complicated, absolute nightmare. So don't worry about it. Let's see. In essence, each of the plaintiffs have filed one or more applications for benefits and was unsatisfied with how the department handled it. After Secretary Washington and the department moved to dismiss the complaint, the plaintiffs filed an amended complaint, which dropped several of their initial claims and also dropped the department as a defendant. Their surviving counts, all of which are federal claims brought under the Civil Rights Act, allege the Secretary's pattern, practices, and procedures violated the Social Security Act, as well as the Due Process Clause of the 14th Amendment. Each plaintiff demanded several forms of relief, including injunctions and blah, 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 blah. Secretary Washington again moved to dismiss, arguing the circuit court lacked subject matter jurisdiction. Plaintiffs lacked a private cause of action, and plaintiffs' claims were substantively meritless. The circuit court granted Secretary Washington's motion without specifying the grounds on which it had based a dismissal. The plaintiff properly filed a motion to amend the judgment, which the circuit court denied. The plaintiff then appealed. Okay. The party's position in this appeal largely tracks their argument before the circuit court. Namely, Secretary Washington argues that this court and the circuit court lack subject matter jurisdiction over the claims listed in the amended complaint because, as he contends, several of those claims become moot. The Social Security Act claims are barred by the doctrine of state immunity. some of the plaintiffs lack standing to seek the type of relief demanded in the complaint, and the Alabama legislature has prohibited courts from hearing claims relating to the making of determinations for unemployment compensation benefits unless the claimants have first exhausted internal administrative review process. Which, incidentally, by the way, this is true of federal regulations. If you want to sue under a federal regulation, you have to first exhaust your administrative remedies. But that is not necessarily the case under state law. But of course, the states can add it, and apparently they did. So they're like, you have to exhaust administrative remedies before you can sue us. But 1983 is an exception to the principle because in 1983 cause of action, you're suing the state, not the federal government. So the principle that you have to exhaust your administrative remedies only really applies when you're suing the federal government, because you're suing them for the federal government agency's failures. And so in a 1983 cause of action, you're not, although it's federal law, you're not suing the federal government, you're suing state government. And so it makes sense that you don't have to exhaust your administrative remedies because you may or may not even have any administrative remedies, and certainly not on the federal level. What makes this interesting is that you're suing in state court under a federal cause of action, on the underlying cause of action, at least, relating to unemployment compensation. And you can't sue, in Alabama at least, unless you first exhaust your administrative remedies. And they didn't do that, which is their whole point, by the way. Their whole point is, like, we weren't able to exhaust our administrative remedies. That's why we're suing. Milton is Cat 5, man? Yeah. What are we reading? We're reading a case that was argued at the Supreme Court today. We're reading a case dealing with 1983 exhaustion. Was Sarah Boone allowed to wear makeup? I'm not sure exactly how that panned out, but I think the answer is yes. This is very technical. So this is a very technical thing, which is, kind of like what I like. I like the very technical because I like the legal, right? So this appeals to my sensibilities because it's a very, very technical legal argument about, do you have to exhaust administrative remedies before you can do this? Can you sue in state court? Can you sue in federal courts? Like, I like that kind of thing. So I hope you do too. I hope you like that kind of thing too. Very, very geeky. Very, very rules lawyer. Very, very rules lawyer. The plaintiffs, for their part, dispute each of these contentions and argue the circuit court committed reversible error by accepting them. We address the jurisdictional disputes first because, absent subject matter jurisdiction, has subject matter jurisdiction been proven for the record, we have no authority to reach the merits. While we must resolve all jurisdictional questions before we reach any merit issues, in situations where we're faced with multiple jurisdiction questions at once, we may decide them in any order. Fair enough. In this case, we begin by asking whether the legislature has prohibited the courts from exercising jurisdiction over unexhausted claims related to a plaintiff's pursuit of unemployment compensation benefits, because it's the only jurisdictional question that applies to all the claims brought by all the plaintiffs. And because we ultimately agree with the Secretary, the legislature has prohibited the courts from exercising jurisdiction over the claims, we end our inquiry there as well. Very, very interesting. Very, very geeky. And then this gets into the Supreme Court said in a 1983 claim, you don't have to exhaust administrative remedies, but which is obviously true if you are in federal court, but we're in state court. And so does that decision apply? Very, very geeky. To understand how and why the legislature has barred state courts from exercising jurisdiction over the types of claims here, helps to understand how unemployment compensation benefits developed in the state. The scheme was initially enacted in 1935. At that time, there's little precedent for such a program. Indeed, Alabama was among the first states in the nation to experiment with unemployment. Apparently, Wisconsin was the only state to precede Alabama. Who knew? Alabama was a trailblazer in unemployment insurance. Who knew? Unemployment compensation is a creature of statute. It does not correspond to any traditional private right and is unknown in common law. Fair enough. When the legislature creates a new type of claim, as it's done here, the procedure for pursuing that claim is completely governed by statute. Fair enough. This is unknown to common law. We've just created it out of thin air So it's subject to the rules that we create for it. I like that stuff. That makes. Can I put a banner on screen saying what I'm reading? I'd have to like, yes, I technically can. Hold on. I'm not sure how much it will help, incidentally, because people have a tendency not to read the banners, as I've learned from much experience, but, you know, I'll put it on. Let's see. What should this banner say? Reviewing Alabama decision on 1983 claim. There, does it help? I need a producer. It wouldn't help, Mandy, because I'm an OBS. So there's no way for anyone to do that for me. Because I'm not streaming in StreamYard. I'm streaming in OBS. I have to do everything myself. Although you feel free to inform people in chat when they're asking. As relevant here, when the legislature enacts a statutory scheme creating unemployment benefits for Alabamians, it specified that anyone seeking such benefits must file application with the department and then await determination by an examiner. If a claimant objects to examiner's determination, he or she must present that objection to one of the internal appeal tribunals, which have the power to adjudicate claims. Only after the tribunal issues a final decision can the losing party appeal. Can you tell us how we can support you? Yes, you can support me by hitting that beautiful, beautiful join button, Zafel. You can support me by hitting that beautiful, beautiful join button, Zafel. And also, the fact that I have moderators who are not members of the channel is not exactly encouraging either, to be honest. It's like, do you really believe in this channel or don't you? I don't know, man. The legislature further specified the procedure outlined above as the exclusive mechanism for seeking, challenging, or appealing any determinations. The Court of Civil Appeals held in Quick that statutory language bars the court from hearing any suit pursuing an unemployment compensation if plaintiff claimant has not gone through the requisite procedures. Secretary Washington argues, in keeping with the logic of Quick, all claims in this case are barred. As he points out, every claim listed in the plaintiff's amended complaint attacks some aspect of the process for making decisions, yet none of those claims have made their way through the mandatory process. Thank you, Miss Mandy Reacts, for becoming an uncivilian. I do appreciate it. Thank you very much. The plaintiffs, for their part, do not dispute that all their claims ultimately demand relief with respect to the administration of unemployment benefits, nor do they argue that they've exhausted their remedies. Instead, they argue that administrative exhaustion remedies does not apply to them because they say the requirement attaches only to substantive challenges, not to procedural ones. The most fundamental problem with the substantive procedural distinction is plaintiffs make no attempt to ground that distinction on the text. Indeed, the plaintiffs briefly ignore the statutory text, which empowers departments' appeals tribunal to adjudicate all disputed claims and other due process claims. Nice. Secretary Washington, however, highlights this language in his response briefs, and with other sections of the law taken together, established the legislature endowed appeal tribunals with the exclusive authority to hear procedural challenges related to the administration of unemployment benefits, in addition to substantive challenges regarding the decision. As he points out, to make little decision for the plaintiffs to contend, as they do, that their lawsuits based solely on departments' failure to timely process claims and provide claimants with due process, while simultaneously taking their suit does not fall under the category of disputed claims and other due process claims. Fair point. I like this. Patsy, okay. When confronted with the statutory language, the plaintiff's only response is to insist procedural administrative exhaustion requirements, such as those contained in law, have been categorically rejected by the United States Supreme Court and therefore, under the principle of vertical stare decisis, cannot be enforced by this court either. In particular, the plaintiffs rely on language from Patsy, in which the United States Supreme Court held that exhaustion of state administrative remedies should not be required as a prerequisite to bringing any action pursuant to 1983. But Patsy does not sweep as broadly as the language suggests. Patsy held only that the text of 1983, a federal statute, lacks an exhaustion requirement. It did not interpret the text of any state law and certainly did not hold state laws requiring administrative exhaustion as prerequisites to state court jurisdiction. That is some very interesting legal reasoning. I like that. That is really geeky. That is so incredibly geeky. That is fun. Even if true, if plaintiffs seem to believe that 1983 preempts any and all independent exhaustion requirements, the preemption would at most allow plaintiffs to bring their unexhausted claims in federal court. It would not allow them to compel state courts to adjudicate federal claims that lie outside the state court holding. I like it. I like it. Yeah. I don't know, man. I don't know. I don't know. I think I might agree with Alabama, but it is an incredibly geeky legal question. That is incredibly technically correct is the best kind of correct. I like that. But I think I might agree with Alabama. But that sounds really, really fun. All right, let's see what else. Let's see what's happening in the news. Man. Has anyone tried suing the hurricane? Let's take a look at the hurricane news. Has anyone tried suing the hurricane? Hurricane Milton strengthens into a Category 5. That sucks. Florida orders evacuation. That sucks more. Milton rapidly strengthened to a Category 5, the strongest level, on a path through Florida, creating a dangerous storm surge in Tampa, and setting the stage for a potential mass evacuation less than 2 weeks after Hurricane Helen swept the coastline. Milton intensified quickly Monday and was expected to become a large hurricane over the eastern Gulf, and maximum sustained winds of 160 miles an hour. Its center could come ashore Wednesday in Tampa Bay, and could remain a hurricane as it moves over central Florida towards the Atlantic Ocean, which I think it will. I mean, Florida is pretty narrow, so I imagine it's going to maintain its strength. Florida gonna get beat up, baby. Florida getting beat up, man. It'll weaken the Category 3 when it hits Tampa. Man, I don't know, man. Take a look at this, man. It's going to go right over Central Florida. Looks like Miami's going to be spared the most of it, though. So that's good, I guess. But Orlando's getting hit. Mickey's in trouble.
Hurricane Milton has rapidly intensified from a tropical storm to a Category 4 hurricane in less than 24 hours. Milton is now forecast to strengthen into a Category 5 hurricane Monday afternoon or Monday evening before slightly coming down in intensity as it approaches Florida. That's because Milton may run into an area with higher wind shear and drier air before making landfall. However, the messaging remains the same. Milton is still going to be a large and dangerous Category 3 hurricane when making landfall along Florida's west coast Wednesday evening. Watches are in effect for the entire west coast of Florida, including inland counties as well, showing that impacts will be felt away from the center of the storm. Highest storm surge will be near and just south of where Milton makes landfall, and that includes Tampa Bay at this time. Flooding is also a big concern, with 5 to 10 inches expected and isolated totals as high as 15 inches. Another major hurricane is threatening.
Damn. Yeah. Tampa going to get hit. But it looks like it's only going to be category 4 or category 3, I guess. So that's slightly better. But Tampa's going to get hit. Orlando's going to get hit. Daytona Beach on the other side. This also is a very strange looking hurricane, by the way. It's just weird that it starts in the Gulf and it's coming like basically completely east. It just seems like an odd track for the hurricane, but okay. But it's 160 miles an hour right now. So on Wednesday it drops to 145 when it hits land at 125. So okay, well that's encouraging, I guess, as far as we go. Is that why the trial got delayed? A little bit, yes. The only thing that could delay the trial is an act of God, and yeah, we got that. I was saying in someone else's chat this morning, I said them, and then I got called out, for saying it, which was kind of the point of me saying it in the first place. I said, "There's only one conclusion to draw: God is on team #free Sarah Boone." Yeah. It's delayed a week, so they're gonna do it next week. All right, let's see what else is going on. There was one other Supreme Court case today. Should we see if that was any good or any interesting? Let's see. Whether post-removal amendment of a complaint to omit federal question defeats federal question jurisdiction, subject matter jurisdiction. Wow. That's so even. That's levels of geeky that I don't think this chat is fully prepared for. Whether a post-removal, wow. That is some geeky ass shit, man. Rural Canaan versus Wolfshager. What a case name too. You gotta love this case name. Royal Canaan versus Wolfshager. Holy shit. You gotta love a case name like that. And then you got the one of the geekier questions I've seen in a while. Whether a post-removal amendment of a complaint to omit federal questions defeats federal question jurisdiction. Wow. And whether such a post-removal amendment of a complaint precludes a district court from exercising supplemental jurisdiction over remaining claims. Holy shit, dude. Where are my Civ Pro addicts? Where are my Civ Pro addicts in chat? Holy shit, I've got to translate that from court into English. Okay. Let's discuss all those words. Yeah, the dog food company. Yes, the dog food company versus Wolfshager, who I'm assuming is a guy. All right, so let me translate all those words because this is pretty geeky shit. All right, so post-removal. All right, what does that mean? Okay, removal is the name for it when a case is initially filed in state court and then it is taken into federal court. Okay, so there's a rule for this, right? You as the plaintiff get to choose like where to file, but there's an exception to the rule. And the exception to the rule is if the plaintiff could have filed in federal court, then the defendant has the right to force it to be filed in federal court, right? So the plaintiff had the choice initially about whether to file it in federal court or not. And in this situation, they chose state court. All right, so the defense can respond by saying, you know what, actually, I want this heard in federal court. I don't want this heard in state court. I want this heard in federal court. Okay, when you do that, it's called removing it. You're removing it from state court to federal court. Personally, I don't think that's a really good name for it because like transferring would make more sense, I think. But they don't call it transferring it. They don't call it transferring from state court to federal court. They call it removing from state court to federal court, Why? They just do. Just go with it, right? So, okay. So what happened is this was filed in state court. Okay, great. The defendant said, you know what? Actually, I don't want this in state court. I want this in federal court. So I'm filing a notice with the federal court and says, hey, federal court, congratulations. This is now a case that you have to handle. Now, the plaintiff apparently turned around and said, you know what? I don't want this case in federal court. I don't want it in federal court. So to solve that problem, I'm simply going to remove all the federal causes of action, right? Because it's my complaint. I'm the one that filed the lawsuit, and I had some federal causes of action and I had some state causes of action. So what I'm going to do is I'm just going to remove, maybe I need a different word. I'm just going to delete all the federal stuff from my complaint, and then it can't be in federal court anymore. Or can it? Or can it? Because that's the thing, right? So the plaintiff tried to delete all the federal stuff from their lawsuit. And the defendant was like, you can't do that. I still want it in federal court. I still want it in federal court, even though there are no longer any federal issues in this case. I still want it decided in federal court anyway. Now, if there were federal claims and state claims at the same time, then the federal court can hear the state claims, right? That is supplemental jurisdiction. A federal court has no initial jurisdiction with respect to state claims. You can't just file a state claim in federal court for the hell of it. But as long as you're there for a federal claim, they can also hear state claims at the same time. That's supplemental jurisdiction. So it's like, okay, do you still have supplemental jurisdiction if there's nothing to supplement it to? What is the lawsuit actually about? I don't know. Should we try to find out what the lawsuit was actually about in the first place? It has something to do with World War II. Okay. Maybe. How can you? If it's removed, common sense would say no. Well, that's what law's for, man. I don't know. Let's read the petition for the writ of certiorari. Anastasia Wolschlager. What a great name. I love this case name. This is a great name. Royal Canin and Nestle Purina, Royal Canin and Nestle Purina versus Anastasia Wolschlager and Geraldine Brewer. This is a great case name, man. This is a great case name. Damn, this is awesome. Thank you. That's very nice of you, Law Elry, to say the workouts are working for me. I appreciate that. Let's see if we can figure out what the hell is going on in this underlying cause of action. What is the lawsuit actually about? This is Civ Pro. This is Civ Pro all the way. This is hardcore Civ Pro, man. Injected straight into your veins. Hardcore Civ Pro. You guys are asking, what's the substance of the thing? I'm like, oh, there's actually substance to this lawsuit? Holy shit. All right. Okay, here's apparently what the lawsuit is about. Here's apparently what this lawsuit is about. On February the 8th of 2019, the plaintiffs filed a class action in Jackson County, Missouri. In their initial complaint, plaintiff alleged that they overpaid for defendant's prescription pet food. Wow. Wow. The dog food prices are too high. Wow. Great. Awesome. They overpaid for defendant's prescription pet food, a product sold only to pet owners who first consulted with their veterinarians and obtained a prescription authorizing the purchase. While plaintiff's initial complaint contained numerous allegations relating to federal food and drug law and regulation, plaintiff characterized their claim as arising under state law, violation of Missouri's antitrust law, violation of Missouri's Merchandising Protection Act, which basically says, don't do the deceptive sales, basically, and common law unjust enrichment. Defendants timely removed this action. The dog food prices are too high. They overcharged us for the dog food. Anastasia is not happy with the amount of money she's had to pay for the dog food. That's what this lawsuit is about. And then more to the point, I guess for the moment, whether or not, having removed all the federal causes of action, whether or not you can continue to hear it. On March the 13th of 2020, the 8th Circuit, okay, what happened below? All right, defendants timely removed this action based on original subject matter jurisdiction for federal question. Plaintiffs filed a motion to remand the action, to unremove it, to remand it. On June the 13th, the district court granted the motion and remanded the action to state court for lack of subject matter jurisdiction. Has subject matter jurisdiction been proved for the record? On March the 13th, the 8th Circuit reversed. I can't believe they appealed this. And I can't, okay. All right. Appealing this court's framework from Gunn versus Minton, the 8th Circuit determined district court did possess. How can you not love this stuff? That's what I'd like to know. How can you not just absolutely love this stuff? It is so unbelievably petty. It is petty on levels that are hard to fully conceive. And how can you not love the pettiness all throughout? I mean, the underlying issue is fairly petty. We got charged too much on the dog food. And then this gamemanship about removing stuff and adding stuff and federal claim and state court and this whole brinksmanship and moving the chess pieces around. Are you not entertained? The 8th Circuit found that plaintiffs relied explicitly on federal law throughout their pleadings, and plaintiffs' dependence on federal law permeates the allegations. With respect to plaintiffs' antitrust conspiracy claims in particular, the 8th Circuit... Daryl Brooks is haunting me. Subject matter jurisdiction. Yeah, I know. He haunts us all. He haunts his all. He haunts my dreams. I totally understand. As evidence coordination conspiracy, plaintiffs explicitly claimed defendants violated the FDCA. They were non-compliant with FDA guidance. The refusal to submit the prescription pet food to the FDA was improper. The 8th Circuit further held that plaintiffs' prayer for relief invokes federal jurisdiction because it seeks an injunctive and declaratory relief, and necessarily requires the interpretation and application of federal law. The 8th Circuit rejected the arguments against federal question jurisdiction, stating plaintiffs' isolated focus on their alleged state claims is nothing more than an apparent veil to avoid federal jurisdiction. This is some maximum petty bullshit, man. Upon return to the district court nearly 2 years after the case was filed, plaintiffs filed an amended complaint on the same day, moved the district court to remand. That is so petty. 2 years and we're still trying to figure out which court it is in. This is great. The amended complaint asserts the same Missouri Merchandising Practices Act claim, but excised, which is to say deleted, dozens of paragraphs referencing the FDCA and FDA regulatory guidance and repackaged plaintiffs' Missouri antitrust claims as a civil conspiracy claim. The amended complaint also dropped plaintiffs' unjust enrichment claim and revised their prayer for relief. The district court denied the second motion to remand, holding the federal question jurisdiction still existed because plaintiff's civil conspiracy claim necessarily raises a substantive federal issue that's actually disputed. Wow. On July the 6th of 2021, somewhere in some law school, a Civ Pro teacher is really, really happy. On July the 6th of 2021, defendants moved to dismiss plaintiff's amended complaint for failure to state a claim. The district court granted the motion. Plaintiffs appealed the dismissal of their amended complaint, but did not appeal the district court's denial of their second motion to remand. During the oral argument at the Eighth Circuit, the question was raised as to whether the district court posed subject matter jurisdiction after plaintiffs have deleted from their amended complaint the original allegations the Eighth Circuit had earlier determined supplied the basis for jurisdiction. The Eighth Circuit thereafter directed the parties to file supplemental briefing, whether it is federal question jurisdiction in this case, and whether jurisdiction depends looking on the face of the amended complaint or the facts that existed at the time of removal, and whether it is supplemental jurisdiction. The Eighth Circuit subsequently held the plaintiff's post-removal amendments had destroyed federal question jurisdiction and precluded supplemental jurisdiction. On that basis, the Eighth Circuit reversed the district court's dismissal of the amended complaint and remanded with instructions to remand the action back to state court. As for federal court jurisdiction, the Eighth Circuit expressly acknowledged its decision creates a circuit split among the courts. To the extent that other courts have come out differently, most have emphasized forum manipulating concerns over jurisdictional rigor. The Eighth Circuit also acknowledged that its own precedent supported the continued presence of federal question jurisdiction, but abrogated that precedent in favor of a 1926 per curiam decision to the contrary. Wow, that's just that is some really interesting. Okay, so the Eighth Circuit is splitting with everyone and splitting with itself. That's some great shit, man. That's awesome. Jim says, you love Kurt when he's like this. He's so happy. I am so happy. I am so happy. This is what I live for. I live for law on the platonic plane. I live for law in the ether. I live for law at its highest level. And this is right up there in the pantheon, man. I can taste the ambrosia. It's being given to me by the gods. Num, 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 num. It's so unbelievable. It's so unbelievable. I'm so happy. This may not be everyone's yum, but it's my yum. And I appreciate you supporting my yum. Yum, 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 yum. How can you not love this shit? As for supplemental jurisdiction, the Eighth Circuit concluded in one paragraph passage, the plaintiffs amended preclude the district court from exercising supplemental jurisdiction. The Eighth Circuit reasoned that it's because the original complaint is without legal effect. The possibility of supplemental jurisdiction advanced right alongside the federal question. Dog law is best law? Bow wow wow yippee yo yippee yay. Bow wow yippee yo yippee yay. Bow wow wow yippee yo yippee yay. Bow wow wow yippee yo yippee yay. I think this is what those rappers were talking about. I think this is what they were talking about. On August the 14th of 2023, defendant filed a petition for rehearing or rehearing en banc and was denied. Wow. Only the Eighth Circuit has concluded in a properly removed action. The district court must move to the amended complaint to determine whether it possesses federal question jurisdiction. Every other circuit has come to the opposite conclusion. Nice. Birds aren't real? I know. Birds are in fact not real. I know. This is so incredibly geeky. What a way to start the Supreme Court term off, though. What a way to start it off. With just a super duper geeky Civ Pro question. What a way to start the day. Let's see what else we got. Oh, ghost guns. Ghost guns are going to be argued tomorrow. We might have to do an oral argument and react for that. Yeah, there's ghost guns tomorrow. Garland versus Vanderstoke. Whether a weapons part kit is designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by action of explosive is a firearm as regulated by the Gun Control Act. And whether a partially complete, disassembled, or non-functional frame or receiver that's designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver is a frame or receiver as regulated by the Act. Oh, the Second Amendment people are like in heaven, man. The Second Amendment people are in heaven. I think we need a new stream, people. I think we need a new stream so that we can go over this. I'm breaking the stream up into parts because I can. Hold on. Yeah, we're breaking this up into parts so that people can, more easily select what they do or do not like. I think that makes sense. All right, so I'll just schedule a new stream and then redirect you to myself. Okay. Ghost guns go to SCOTUS. Can they be regulated? Reviewing briefs in what is the name of this case? Garland versus Vanderstook. Nice. All right, schedule it. Is this out of the Fifth Circuit? Of course it is. Okay, guys. We're going from geeky Civ Pro to Second Amendment. Wow. This is an interesting day. All right, guys, I'll see you in 2 minutes, okay? All right, love you. Bye.